Welcome everyone in the webcast audience. I'm Terry Maggedy, chair of the Elder Law Committee of the Trust and Estates section for our bar. And the first thing we do, though, before we start our program is turn to our sponsors, because they're the ones that really allow us to make these programs happen with their generosity. And we'll turn things over to first the sponsors that are here in person, and then I'll mention the sponsors that are not in person. So we'll start with Nancy Sanborn. Nancy?
Hi, Terry. Thank you very much. I just want to wish everyone a happy new year. I can't believe we're starting year 3 of COVID and remote things. We were just talking about how much fun it is to be in person. I just want to thank all of you for your support these past few years, and to tell you how proud we are to have been supporting the Bar Association for over 15 years. So I know you're going to have a great meeting. Terry puts together some of the most relevant topics in dealing with elders. I think that we in real estate see an awful lot of elder abuse, and I think it's something that we really need to be aware of. So have a good meeting. And Randy, thank you for your wonderful advice. Thank you. Have a good meeting. Bye, Terry.
Thanks, Nancy. And now, Orit, you're next up.
Thanks, Terry. Hi, everyone. On March 9th, I'll be presenting a webinar here at the Beverly Hills Bar titled Mistakes That Real Estate Agents Make That Can Cost You and Your Clients. That's at 12:30 p.m. Please join me. The link to register will be in the chat box. I'll be discussing various errors that probate and trust agents are making. Join me to learn how to correct them and to protect your and your client's best interest and minimize liability. On a different note, if any of you need help with the disposition of any real estate assets, commercial or residential, please let me know. And for those of you with properties in an estate or trust that don't have sufficient funds to handle a clear out, cleanup, and or a renovation, please reach out. My team can help. Enjoy your program, and back to you, Terry.
Thank you, Orit. And now we'll go to thank the sponsors that aren't here with us in person. First, Marcine Klein and Glen Oaks Escrow, an escrow company that specializes in the areas we all deal with: fiduciary sales, probate sales, conservatorship sales, all sales relating to older people. Marcine's got a real nice expertise in this area. So thank you, Marcine and Glen Oaks Escrow, for your sponsorship. And next, California Title Company, another organization that specializes in areas that we deal with: probates, fiduciaries, trusts, conservatorships. Thank you, California Title Company, for your sponsorship. And our newest sponsor I want to thank is Manufacturers Bank. Manufacturers also has developed a niche in our area. Probate, conservators, trustees. I repeat it each time, but everyone knows the type of work we do, who are the people that attend these seminars. And so thank you, Manufacturers Bank, for being a sponsor and creating this niche market for the bank in our area. And you'll receive your MCLE credit certificates shortly after the program. But next, I'm going to mention our program coming up next month. And the title is In-Home Caregivers, the Advantages of Hiring Legally and the Consequences of Hiring Under the Table. Our speaker, Bob King, attorney, founder of an outfit called Legally Nanny, is talking February 28th. Bob's been around a very long time, has really developed a niche expertise in this area. And everyone deals with this, for sure people in our industry deal with it all the time. Hiring caregivers, doing it legally, maybe people not doing it legally. So you can come to our next program, February 28th, to hear more details about that. Now for our speaker today, who's been somewhat of a regular to our group, Randy Spyro, long time estate planning attorney, been in the business for many, many years, has a tremendous amount of expertise. And usually at least once a year, we invite Randy to come on board and just pick a topic of interest. And He's done that for a long time now, and they're always subjects that people are very interested in knowing about, and they're regularly great presentations. So that's why we keep inviting Randy back. That is one of the consequences, be it negative or positive, for providing us with good programs. So thank you, Randy. I'm going to turn the program over to you now to talk about the topic, which is identifying and avoiding malpractice. That's something that's of interest, I'm sure, to everybody, and ethical pitfalls with your older clients. Randy, the program is yours.
Thank you, Terry. From law school, all of us are familiar with this IRAC method, issue, rule, analysis, conclusion, but I don't know that we've applied it directly to malpractice and ethics. Ethics is increasingly becoming a method to use in a malpractice action, that if you did something unethical, that it is also evidence of malpractice. So a lot of this is more issue spotting rather than the conclusion, because some of you may have different conclusions. A lot of you may have different conclusions than some of the ones that I come to. So with that in mind, and from my outline, you've got a client that did not understand what he or she signed, or at least that is what the claim is. The argument could be that the document was too long, that the document was too confusing. A lot of us have CYA letters, but a typical CYA letter covers lots and lots of topics. And so if the client didn't understand the trust, the argument would be he didn't understand the CYA letter. And so if you've got 1, 2, 3 burning or difficult issues in an estate plan, you could isolate those in separate letters that discuss what is going on, and have the client read that, and also have them countersign that letter, so that if he says, I don't remember reading it, I think it's going to be harder for the client to say he didn't understand a 2-sentence letter than a 5-page letter. So for example, a client may not have wished to avail himself of some estate tax saving strategy, is that documented anywhere, or was it that you didn't tell him about it? I just had a client where he wanted to impose the estate taxes on the charity that was getting the remainder, and I explained to him that by doing that, it reduces the charitable deduction and increases the tax, and you have to actually run the program about 7 times before you get to the ultimate tax, which keeps going up. And he didn't care; he wanted it that way. But I've got documentation in my file that that's what he wanted. It wasn't that I didn't explain it to him. Number 2, reasons client wants a simple will to save money. I think that's the biggest reason. To avoid receiving a punch list of funding instructions of how he holds his assets. And that's the scary part, because if the client doesn't really want to get into how he holds title to assets, then we don't know who's going to get these assets that are passing under beneficiary designations that we haven't seen, and the client doesn't want to cooperate with us in showing us those. And does the attorney have a duty to hire an auditor? Well, I don't know. If the client doesn't want an auditor, or do we document that sort of situation? Who is going to coordinate the probate and the non-probate assets, how they're going to pass? Can a will reaffirm methods by which assets may pass outside the will? So you could have a will that's a pour-over will and says, I give everything to the trust, but in that will, it can reaffirm that that there are joint tenancy assets, or there may be joint tenancy assets, and there may be beneficiary designated assets. And so the will makes it clear that the client reserves the right to not pass all his assets under the will, and that can be helpful. And if you have particular assets that you know, so for example, the house is remaining in joint tenancy between the spouses and not going into the trust, the pour-over will could make reference to that. So it's clear that the client didn't want to sever the joint tenancy. And so we're talking about CYA letters a lot, but for every CYA letter, ask yourself, is this a CYA letter that will be an exhibit in a malpractice action? In other words, the consequences, or the people being angry is so likely that even if you've got the letter, you get sued anyway, and you can just bring the letter in as an exhibit, which is better than nothing. But it goes to the issue of whether the attorney even wants to take on the representation. And with LegalZoom, We the People, paralegals, do-it-yourself, estate planning is becoming a greater and greater field for trust and estate litigators, because people are doing more and more do-it-yourself, and there's going to be more and more exposure for mistakes. Assets outside of the United States, do they get caught up in the web of your pour-over will? Your will says everything that's not in the trust I give to my trust. Can you exclude that? Can you say in your pour-over will, I give all my assets to my trust except for assets located outside the US? Certainly you can say that. Will the client create a separate estate plan or a separate will in each foreign country? He may or may not, but your letter to your client recommending he do that, countersigned by the client, very helpful. Do the foreign advisors know about the US estate plan? Have they been sent a copy? Not often. Not all foreign countries recognize US estate planning documents, particularly trusts. Actually, Roman numeral 3 would be US trusts rather than US wills. So when a client calls me with a trust and I see there's a letter about doing a will in a foreign country, I ask the client, did you do that? Did you do that will? Well, not yet. Well, I'm thinking, well, 3 years ago you did this trust and you haven't gotten around doing the will. Maybe I have to push harder and send you a reminder letter again about this issue of doing the will in the foreign country, because clients aren't necessarily wanting to do what we tell them to do. That is more common than uncommon. All right, Roman numeral 4, client creates and signs an amendment to his trust and sends you a copy. Why does he do that? He wants to save money. He doesn't want the lawyer to do it. If you put that amendment in the client's file, what if the amendment is wrong? Will the client pay you to analyze the amendment? Maybe, maybe not. What about a detailed response back to the client? We need to meet to discuss your intent and to clarify it if necessary. If I don't hear from you, I will no longer be your attorney. I am not responsible for errors in the amendment that you drafted without legal representation. Well, that's a great way to lose a client, but this client who is doing his own amendments, maybe he's not the greatest client, and maybe you don't need or want somebody to say later that you are responsible for the errors in that document because he sent you the amendment, and the fact that you didn't charge for it notwithstanding. Now, I don't know if that's true or not, but certainly I could see that argument surviving summary judgment. And surviving summary judgment is one of the things that those that are angry with an attorney want more than anything else, because then it becomes settlement time. Roman numeral 5, client calls and says he wants one child to be co-trustee with him. Well, what role did that child have in the decision for the child to be co-trustee? Maybe we have to burrow into that. Did the client or the child only want there to be access to one or two bank accounts? And this is an interesting one, because often you get somebody calling and say, I want co-trustee, or I want somebody to take care of something. But what the client really means is he's got 26 assets or 9 assets, but he only wants the child to be on 1 or 2 bank or brokerage accounts. So here's one solution. It's not the solution for everything, but it's one example of a discussion. What if the bank accounts were removed from the trust, and then the child was added not as a co-owner, but as a power of attorney on the account with the bank's power, and then the account is made payable in death to the trust? Now, what's the effect of that? Well, the client remains sole trustee of the trust, but that one asset, he's given that one child access to that one account. So if there's $25,000 in the account and the child steals it, he's stolen 25,000. He hasn't stolen 25 million. So that's a thought. And if the child is sitting with the client in your office, how do you know whether or not the client is afraid of the child? So a lot of times when the child is being brought in, it could be better to exclude that child so that the lawyer can make his own determination. And we really can't make a determination in the sense that we don't know what's in the client's heart, and we don't know what happened yesterday or 5 minutes before the client got in his car to come to your office. but we can at least say that we met privately with the client prior to this process, and we did what due diligence we could. Okay, a lot of us or all of us know about the California Bar Ethics Hotline. And sometimes I get calls where a client has died and the attorney for a non-trustee beneficiary, he's the beneficiary but not a trustee, he calls the drafting attorney, me, he calls you, and he wants to pump you, get as much information as possible. And the drafting attorney can say, or should say, I can't talk to you. But that's not enough for the caller. He's threatening you. He's implying that you did something wrong because you won't answer questions, or that he's entitled to know. Well, I called up the Bar Ethics Hotline and I said, what do you do in that situation? And the person on the other end says, call us and tell us that that's happening because we want to know about it. So I said to myself, well, that's a really good thing that I can tell this not too polite caller. And I have several times, and every time, for some interesting reason, the caller has backed off. He didn't want me to call the ethics hotline and explain to him what that caller was doing. All of a sudden, maybe my idea that he's got to deal with this situation differently occurred to him. Anyway, Roman numeral 7. Client has given one of the trust beneficiaries, the drafting attorneys, your phone number. So how can you, the attorney, determine if the caller is the undue influencer? How can you, the drafting attorney, determine the scope of what the client wants you to discuss with this caller? Absent the client's informed consent, the attorney must maintain confidences and preserve secrets. That's the Business and Professions Code and Rule of Professional Conduct. The client may just want to be left alone, and the client may need protection against the caller. But we come up against California Bar Ethics Opinion 1989-112, where if the client wants to be left alone, even if we think the client needs help, we can discuss it with the client, but without the client's consent, we can't do anything to protect the client. So, but we certainly don't have to and shouldn't go along with these callers where the client, we don't know what the client wants. Certainly we can try to identify what the client wants, but in some cases the client doesn't want us to get in our car and drive out to the client and drive back and run up a bill. So, but at least by phone we can make question about what the client wants, and sometimes the client doesn't know what he wants, and that makes it even more fun. Roman numeral 8. Can the attorney be polite and yet get the attorney's message across? Maybe yes, maybe no. So there was a case where I was doing a trust for somebody and they brought me their deed and their home, and they also brought me their tax bill. And somehow I took a closer look at the tax bill, and I saw that the track number was 1 digit off, 1 digit different, 352 on one and 325 on the other. There was something transposed. So I said to the client, call your title company and have them fix it if this is an error, and we'll sign the trust, but your title company can help you and fix it if it's an error. So the client comes back, and I said, well, what did the title company? He says, well, I didn't have a chance to tell them. So I realized that the way I was saying it wasn't getting my message across. So I said to him, well, you don't own your home. What are you talking about? Well, you got a wrong legal description, and you don't have title to your home. Well, the client started yelling at me. And but you know what? Even though he got mad at me for telling him the truth and ultimately helping him get title to his house, now he went home and he called that title company. So sometimes being polite is not helpful if we're not getting our message across. And sometimes we have to get less polite if that's what it takes to do our job. And hopefully that doesn't happen a lot, and hopefully it doesn't happen every day. Roman numeral 9. If a trust amendment can be done by phone, why can't a resignation by the settlor as trustee also be done by phone? Well, there's a lot of lawyers that say even trust amendments cannot be done by phone, and I understand that and I respect that. But often we send out amendments to clients and we suggest they come in to sign them. Yes, there's an issue of being better off, being more diligent if we supervise the execution, but sometimes the client's going to haul off and sign that amendment without us helping, and we've got to deal with that. But be that as it may, I make a big distinction between a trust amendment where perhaps the client, whether we advise against it or not, will sign that amendment, and a client actually resigning as trustee, and you get the client or the client's child calling and saying, you know, I want to resign, or my dad wants to resign. I don't want to handle that by phone because I really want to be involved in the determination of the client's competency, which I believe I can do better, not perfectly, but better in person. And also, I want to be involved in trying to figure out if the client has freedom from undue influence of others. If the client comes in, I've got a better chance of that. And also discussing with the client's level of trust in the successor trustee, because we talk about powers of attorney being a license to steal. Well, same thing on trusts. When you name somebody else as trustee, they could do some pretty bad things before you find out about it. So if the client may be worried about the cost of multiple trips for you going out to the client, so let the client come to you. No, I'm too sick. Well, then I'll come to you. No, that costs too much. These are practical issues, but you have to weigh the issue of protecting the client. Roman numeral 10, joint trust during a divorce. You did a trust for a husband and wife. Now they're going through a divorce. There's a temporary restraining order, Family Code 2040, and that's going to prevent amendments to the trust unless the clients agree to that, or some sort of stipulation, or the court under a petition orders that the temporary restraining order be lifted or waived in a way that facilitates the amendment. But I think family lawyers have rarely done them. There may be some that have done a lot, but a lot of lawyers have not done any. And some family lawyers might not even suggest to the clients that they do this. And the client himself is often fed up with the cost of the divorce process. And now there's further cost for this petition or negotiation for a stipulation. And not only is it that, but there's more contentiousness over this issue of amending. So it can be difficult for the drafting attorney to get involved in this. And when the clients aren't necessarily going to cooperate, aren't necessarily going to spend what they need to spend, and the divorce lawyer may not be cooperative either. But it's an issue, and I think we should have in our mind what we feel we are or aren't willing to do when the situation comes up. Now, here's probably one of the worst ones of all my outline. Are damages a bigger liability factor than negligence? Well, in malpractice, negligence is or alleged negligence and duty of care is discussed a lot. But what happens when our client goes to a litigation attorney? Are there some litigation attorneys, hopefully not all, hopefully not a majority, but are there some, as the client discusses the problem where he's worse off because of something happens, and the attorney says, hold on a minute, if it happened this way, you've got a weak case, and if it happened a different way, you have a strong case. Now the client, which way did it happen? And then the attorney stops him again. Well, if this happened, you'd have a weak case, and that happens a strong case. If you've got that kind of coaching going on, in essence, the litigation attorney might be feeding the client with what he has to create against the estate planning lawyer. And now you've got these, in your mind, in my mind, phony allegations. But if they're a question of fact, can they survive summary judgment? So in assessing taking on cases, in a way, we have to have some thought about what some litigation attorney might do with the client in the future in terms of feeding him with wrong stuff or things that didn't happen. Now, the CYA letters that we've talked about, they help a lot. They don't help completely, but they help a lot, because if you've got somebody that says you did X, and you've got a very clear CYA letter and it's countersigned, that might, not always, but it might knock down the whole case against you once they see that they've told you something and the letter says just the opposite of what it's being claimed that you failed to do. Roman numeral 13, Client calls requesting an amendment to reshuffle percentages of what his children will inherit. Will the benefited child bring the parent to the attorney's office? Did the benefited child make the initial call to the lawyer? Welfare and Institutions Code says that undue influence means excessive persuasion that causes another person to act or refrain from acting by overcoming that person's free will and results in inequity. So the idea that we try to keep the benefited person out of the process is a good one. And the person who is calling you wants to inject himself in, may be very pushy. But if we accede to their wish to let them be involved, and then later their involvement is used against them to knock out their gift, could that pushy person come back and sue the attorney and say, well, you know what, I was the intended beneficiary, and by allowing me to participate, you caused me to lose my gift. So, yeah, but I tried to keep you out of the picture. Well, you were the lawyer, I wasn't. I didn't understand. So the very person who's pushing you to allow their involvement can be mad at you if you allowed their involvement. And I think that it has a possibility of happening. Roman numeral 13, client calls requesting well, that's 13. Roman numeral 14, a joint tenancy severance by an attorney for a single client. So the client has a joint tenancy with somebody else or more than one person. Civil Code section 683.2. If the other joint tenant is the survivor and you don't sever, maybe is there exposure to the trust beneficiaries? Because if you severed the joint tenancy, you could put the client's share in the trust and they'll get it. So if you didn't sever, it goes to the other joint tenant. If your client is the survivor, is there exposure to the client if you sever? Because you severed it, now the other person died, the client doesn't get their share. So the CYA letter issue is very important because you're not telling the client to sever or not. You can lay out, you should lay out the ramifications of severing or not severing, so that when the client signs and checks a box as to sever or not sever, it's based on you're disclosing to him or her the ramifications going both way. And then I've got Family Code section 721, and we're going to come back to that later. Is it a violation of that fiduciary duty among spouses for one a client to sever a joint tenancy, record the deed, and not tell the other? And if you're the lawyer, do you even want to get involved in this unilateral severance where your client doesn't want to tell the other spouse about it? I think these are problems that we have to think about. Either A, whether we even want to get involved in the case, and B, how are we going to handle the case in the best way? A big area, which I think you've heard about, a lot of you have attended seminars on it, is Family Code section 2640, the reimbursement right. So that if one spouse owned a piece of real estate, for example, deeded it from himself to both spouses, then for purposes of divorce, that spouse has a reimbursement right in the divorce proceeding equal to the equity at the time of the conversion. Well, do you waive that or do you not waive it? Well, if you waive it, then there's exposure to the waiving party, and if you don't waive it, there's exposure to the non-waiving party in either case in divorce. And remember, there's a case that says that when you've got this reimbursement right and you sell that asset, the reimbursement right can carry on into other assets. So if you see this issue, you can have a CYA letter to the client where he countersigns it, saying that not that you're going to help him waive it or you're not going to help him waive it, but that because you have a conflict as to whether or not the client should waive, you're presenting the issue to the client, so that if they want to go to other advisors, other attorneys to waive or not waive, that you're out of the loop, but you're presenting it to them. You're telling them this is not something you're going to get involved in, which I think is the right answer. Roman numeral 16, you got specific gift of real estate, but it's silent on whether it passes subject to the mortgage or whether the mortgage is exonerated. And the probate code section says that if it's silent, if the instrument is silent, it passes subject to. But I think a silent instrument is another problem, because you want to say in the trust or in the will, free of or subject to encumbrances to establish that which way the client instructed you, because if it's silent, you've got a statute. But if somebody alleges the client wanted differently, you've got nothing to show otherwise. And language in a trust or will to pay debts is insufficient to override the statute. So we really want to document following the client's intent. So if you have an AB trust, this is Roman numeral 17. Normally, the B trust on the 706 will not be deducted anywhere in Schedule M. So you're going to wind up subtracting the B trust, the credit shelter, the exemption trust from the portability amount. This year, the 12.06 million. But if you've got a bypass trust that gives the spouse mandatory income payable at least annually, and there are no other beneficiaries during the spouse's lifetime, then that trust could be Q-tipped, could be deducted on Schedule M on the top. And whether it should or not is not the point. It could be. Now, if you Q-tip that bypass trust, it does not reduce the portability amount, which is good. And if you Q-tip the bypass, then it gets a step up on the second death, which the bypass normally doesn't when it's not Q-tipped. On the other hand, if you Q-tip the bypass, you haven't frozen the bypass. So if the bypass trust doubles and triples during the lifetime of the survivor, by Q-tipping it, it's includable on the second death at its value at the second death. So Q-tipping the bypass is a question, because there's pros and there are cons. And if it's not Q-tippable, then that's the end of it, but it may be Q-tippable. Now, Roman numeral 18, should an attorney for a couple get involved in transmutation? We all probably know the rules of the McDonald case, subpart A, where you need a express declaration to transmute, and all the cases where people thought there was an express declaration, and sometimes the court says there is, and sometimes the court says there isn't, and the civil code section that codifies McDonald. I want to talk about a case called, it's an unpublished case called LICO. And in that case, a husband had separate property interest in a family business. The estate planning attorney told the couple about the double step up and basis for community property, but not about the effect of transmutation on divorce. So the clients based on that said, okay, let's transmute. So an agreement was made to transmute the separate property to community, and that the reimbursement right on Family Code 2640 was waived. The agreement complied with Family Code 852, but that didn't foreclose the presumption of undue influence under Family Code Section 721. So to rebut it, the court said the advantaged spouse must establish that the disadvantaged spouse's action was freely and voluntarily made with full knowledge of all the facts and complete understanding of the effect. So in this case, even though the trial court in the divorce found that the wife took no action to unduly influence her husband, it was the estate planning lawyer that brought up this issue, and she didn't say anything yay or nay. The fact that the husband didn't understand the impact of transmutation meant that the presumption of undue influence was not rebutted even by proving that there was no undue influence. So that's an interesting case, a strange case, but a case to think about, that you can have a presumption of undue influence that cannot be rebutted by proof that there was no undue influence, because under Family Code 721, all you need is this unfair treatment, that one spouse was disadvantaged. So this LICO case, it's unpublished, but it's a case that you may want to read. Also, to go to D on this, you've got issues of conflict waivers. And there's an article, an old California bar article, that says there's an unwaivable conflict. In this case, number 4 from the article. The lawyer is precluded by duties to one client from making sufficient disclosure to the other, rendering the latter's informed consent unobtainable. So when is the consent unobtainable? When you're trying to create a conflict waiver? Well, the clients are sitting together in your office, and one client is uncomfortable about revealing one or more key facts to you because the other client, your co-client, is sitting there. So sometimes when the clients are sitting with you, there's an issue of whether you can get from them all of the information necessary for an informed consent, because one client is worried about something. Now, if the client says, this is I put some money into this building, even though we bought it together, I put some separate property in it, that client may be worried to tell you that, and there's no way to find that information out in some cases. And the client is afraid to tell you that, because if the wife hears that, she might think that he wants to divorce her, and he doesn't want to divorce her, but he doesn't tell you what you need to hear. So informed consent may be unobtainable in situations where it seems obtainable. It seems like the clients have told you everything, but they haven't told you everything. Anyway, Roman numeral 19, on a community property IRA, the spouse needs to consent where the spouse is not the primary beneficiary. And there's a couple of probate code sections, 5012 and 5030. So can the attorney represent both spouses? And this is a problem that we have to slow ourselves down, because I think you need to have this spouse that's consenting either get their own lawyer as to whether or not to consent, or if it doesn't go down that way, some lawyers might say, I'm going to recommend that spouse get a lawyer, and I'm going to tell the spouse that I'm not their lawyer for purposes of this because I have a conflict. And then if they go ahead and sign it, that's okay. Well, I don't know if it's okay or not, but at a minimum, backing yourself out and saying, I can't be the lawyer in advising you as to whether or not to sign this consent because I have a conflict. But then if you say that they have to go to another lawyer and they refuse to go to another lawyer, do you say, well, I guess I can't represent anybody, the whole estate plan is off? You know, these are questions like with everything. Economically, we could lose a lot of clients, and sometimes we have to. But the question is, where do you hit the line, and where do you cross the line? You have to see the line in order to decide for each client, for each attorney, for his specific situation, where he's crossing it or not crossing it. Now you got a specific gift of real estate. I give a piece of real estate to child A and everything else equally to children A and B. Well, gifts like that lapse if the asset is not owned by the client at death, unless the instrument provides otherwise. Well, there's probably a lot of specific gifts in wills and trusts that say, I give this piece of real estate to my son, and if he's not living, it lapses, or if he's not living, it goes to his issue. But in many cases, the instrument does not say, but if this asset does not exist anymore, this is what happens. But it takes a couple of extra questions to the client. Well, what do you want to happen with that property if it's been sold? Well, often they'll tell you if they bought another property, it goes into the other property. Sometimes they'll tell you they want the proceeds from the sale to go to the same person, but then it's often only to the extent that those proceeds are still in the trust. But not saying anything is a dangerous issue, because then the client will say, well, you know, my father wanted me to get the proceeds from the sale, and you misdrafted it. But you've got to ask the question and document that whatever you did, you put in what the client wanted. So in essence, don't rely on the fact that the statute has an answer instead of having a documentation that you implemented what the client wanted to do in that event. And unfortunately, a lot of the times the problem is that if you talk to the client, you say, well, what happens if the property doesn't exist anymore, it's been sold? Sometimes the client is not sure what he wants. But you have to say to the client, if you need more time to think about it, that's okay. But ultimately, it's better that you take your best shot about whether you want it to lapse or to carry over in some way to some replacement asset. The client should decide. All right, Roman numeral 21. Client is a self-formed LLC owning multiple real properties. So more and more of my clients are coming in. Somebody has helped them, LegalZoom, their accountant, God knows who, form an LLC, and they've got a bunch of real properties in that LLC. Well, we all know that one possible reason for forming an LLC is to have limited liability. But a lot of our clients don't realize that it's the assets outside of the LLC that are protected, and that the assets inside the LLC are not protected. So if you have multiple pieces of real estate, and I'm preaching to the choir here, I'm not telling most of you anything new, multiple pieces of real estate inside of one LLC, then they got a problem with one property. It could infect, and you could lose all of the properties inside there. But this client has come to you with this situation already in hand. So the question is that situation analogous to a client who comes to you with a stock portfolio, and you're going to set up a trust, and you're going to retitle that portfolio from John Doe or John and Mary Smith to that trust, and you get the owner change. Now, I don't think in general by doing that the lawyer becomes liable because there were risky investments inside the portfolio. And why didn't the lawyer go back and analyze the investments in the portfolio at the time he transferred the ownership to the trust? Well, I think it's somewhat clear to me that the lawyer isn't being asked to do that. So someone could say, well, when you do this, how the client has an LLC with multiple properties in it, and all you're doing is changing the owner, the member of the LLC from the client to the client as trustee of the trust. And if there's a co-member, you're getting their consent, then you're not responsible for the assets inside. Well, I don't know about that. I feel somewhat different about that one, because you've got this self-formed LLC. The client never had a lawyer explain it to him. And if you hopefully do explain it, the client says, well, I'll think about that. Well, think about it means you'll say, all right, there are 3 properties in there. We're going to take 2 of them out, and we're going to create 2 more LLCs, and we're going to deed the 2 that were in there into the 2 new LLCs. So now you have 3 LLCs instead of each owning 1 property. And the client says, well, either no, I don't want to do that, or I'll think about that. Well, now you've got this client wanting you to create a trust and popping the LLC interest with the multiple properties in, because the client doesn't want to form more LLCs because of the cost, even though one argument is he did the LLCs to limit his liability. Well, at a minimum, you want to have a CYA letter that you recommended the client do this, and he said no. And there may be it may be you want to walk away from it entirely, in the sense that maybe there's too much exposure there to the attorney, and you just don't need it. In fact, on this particular one, and all of us have our own predilections, on this particular one, I would be much more disposed to walking away, where the client either isn't going to create multiple LLCs, or says, yes, I'll think about it, but in the meantime, let's create a trust and pop this LLC interest into the trust. Well, I think there's just a lot of problems there. Last one, and then maybe I think we'll have some time for questions. Can a prenuptial agreement in which spouses agree that each party's earnings during marriage is the earner's separate property be a fraudulent conveyance? So from the get-go, each party has separate property, and the one that's earning a lot is protected from the debts of the other one in some circumstances because of the separate property, or his separate property is protected. Well, there's already one court that said that yes, a premarital agreement could be a fraudulent conveyance. Well, I don't put this in specifically for those facts, but just the real fact that some estate planning attorneys could, and some attorneys maybe should prepare premarital agreements and postmarital agreements, maybe because they're also involved in divorce. So if they're divorce attorneys, maybe they have acquired the expertise to do pre and postmarital agreements. But if you're an estate planning attorney who's never done divorce, then how much more do you have to bring yourself up to speed in the divorce area to prepare a pre or postmarital agreement competently? So a lot of times you're doing a separate trust for somebody, and either they want you to do a postmarital or a premarital, or you bring it up and they say, all right, fine, you do it. I think the estate planning attorney has to approach pre and postmarital agreements with great reluctance, unless you've done whatever extra due diligence to make yourself familiar with what can go wrong in a divorce, probably to the same level as as that divorce lawyer, because it's those divorce/family lawyers that do it that are going to be the expert witnesses and are going to be looking at what you did with the client to prepare him or her for the situation. And you may be representing the poor client in the sense that they're agreeing to waive all kinds of things because they want a higher lifestyle, and later they want to repudiate that. Or maybe the rich client is relying on the agreement, but because some step was missed, the agreement is not honored. So I think estate planning attorneys have to be very careful in evaluating whether to get involved in premarital agreements and postmarital agreements, just like getting involved in doing estate planning for your clients that are divorcing, because before they were divorcing, when they're your joint clients, they signed your conflict waiver, they had no conflict. Well, now they've got a major conflict, and but to save money, they would like to have one lawyer get involved in making an amendment, or maybe one wants it and the other doesn't, or maybe you don't know what they want until you wade into it. Then once you've waded into it, it's too late. And so this issue, it pervades a lot of what we've talked about today. Putting your toe into the water, putting it in before you know whether the water is freezing cold or boiling hot or just right, like the porridge in the fairy tale. So Terry, I think we've got some time left, and I'll turn it back to you if there's any questions.
Great. So I will, let's see if there are not any questions. I always have questions. So let's just make sure. So I don't see anything in the chat, and I don't see anything in the Q&A. So I'll ask a couple questions, but in the meantime, while I'm asking, if anybody else in the audience has something, just, put it right out there, because you take priority over me. Couple of things. One, you talked about an interesting issue about a duty of one spouse to notify the other spouse of a severed joint tenancy. And believe it or not, the issue comes up in elder law practices. Sometimes you have a spouse who doesn't have capacity, and the one with capacity is severing the joint tenancy, often just in a way to actually help the other spouse. But have you run into cases that where there could be liability beyond just the disclosure element, which is usually you think of the right to sever a joint tenancy as a right, but if you are a spouse of someone, do you really have that right? Or is there something more that needs to happen besides just telling your spouse, oh, I'm about to sever the joint tenancy? And also, if there is even this right of disclosure, if you have a spouse who doesn't have capacity, what happens there? Any comments on anything I've said?
Yeah, absolutely. I have one example, and you could have 100. A husband and wife each have a different child from their prior marriage. They have their own separate child, and they have their major asset in joint tenancy. And they each have a simple will that says, I give everything to my spouse.
Yeah.
Now, one spouse decides that he doesn't want to risk, if he dies first, that everything goes to the other spouse. So he severs the joint tenancy, and he creates a will giving that half to his child, but the other spouse doesn't know about it. So if the other spouse dies first, there's going to be a probate of that spouse's half going back to the guy that did the severance. Right. And now the child of the one that died first figures this thing out and says, wait a minute, there's a severed joint tenancy. Let me see your will. And if he sees that the will, well, but my mom would have done a new will if she knew that you had severed, because that would have been a big slap in the face, and she would see what you're doing. But she was denied the opportunity to have a fair turnabout. And so that's just one example of that child of the other one, trying to make something of it. So
severing a joint tenancy comes with risk. It's not just inalienable right, like the Declaration of Independence or the Bill of Rights. It comes with risks, even if you're just an individual even if you're just representing one person. Do I have that?
So you're not representing the other spouse.
No, you stay away from that.
But in essence, the spouse that you represented could be liable for all kinds of things under the 721 fiduciary duty. And so first there's this issue of informing your client about their potential liability, and second of whether you even want to get in the middle of it. Wow,
excellent issue. And now we do have some questions. We have, I know from if somebody said, sorry, brand new attorney. What is interesting? You've taken the noun Q-tip to turn into a verb, Randy. Could you give an explanation for just of what when you say Q-tipping? Could you elaborate on that expression a little bit for us?
Thank you. For estate taxes or inheritance taxes, it's not inheritance taxes, but it's federal estate taxes. You have an exemption or a free amount, and you also have a deduction, unlimited deduction for gifts to charity. But in addition to the deduction for gifts to charity, you have a deduction for gifts to spouses. And the classic deduction for gifts to spouses on the 706 on the estate tax return is for outright gifts. But there's a second separate category called the Q-tip trust. So if you create an irrevocable trust where your spouse gets the income from it mandatory, at least annually, and there are no other beneficiaries during your spouse's lifetime, then you can say, all right, when my spouse dies 10 years after me, that trust can bounce back to my kids, and that way I'm protecting them, and you can still deduct the property that you put into that trust and postpone the estate taxes on that Q-tip trust until the second death. So this Q-tip trust, and so Q-tipping is saying you've got a Q-tip trust and you deduct it on the top of Schedule M of the estate tax return. So if to give you an example, let's take the estate tax exemption is 12.06 million, but if you use 12 million as a round number, and if a married couple had 30 million and they had what's called an ABC trust. So the A trust would be the survivor's trust, would be 15 million. The B trust would be the bypass trust of 12 million. And then there'd be a 3 million Q-tip trust. Well, everybody agrees you Q-tip that trust C, that Q-tip trust. But the point of my talk was that 12 million bypass trust, in some cases you might want to, or in other cases you might not want to Q-tip it. So it's Q-tipping the B trust, which is not the classic Q-tip trust. It's the C that's the Q-tip, but can you Q-tip the B? Some yes, some no. And if you can, should you? So this is the beginning of an analysis rather than the end of one.
Thank you. And by the way, thank you for the question, because I love it when people, it's good. Whenever you ask a question, you think, oh, it's too simple of a question. Usually you'll find that there are many other people on the line who would like an answer to it. Okay, another question. Are you saying that if a person has 5 rental properties, each one should have its own LLC if liability is a concern?
Well, I'm saying yes, even if it's not a concern, because the client has no concern for liability until he has a concern for liability. And the point at which he has a concern for liability may be at the point where the first liability jumps out. So in the beginning, he doesn't have a concern, so he puts it all in one LLC. And if the advisors just kind of roll along, which if you did it on LegalZoom, there are no advisors in essence that want to come to the plate and say it's my fault. So now this estate planning attorney is inheriting this act that the lawyer didn't do of finding these 5 properties in one LLC. And at some point, will the opportunistic client say, well, you should have told me to have 5 LLCs. And the lawyer says, well, I didn't form the LLCs. You did it without me. And the client says, aha, but you had the opportunity when we did the estate plan to advise me to do it differently.
And we have another question, which is, I don't understand how the pushy beneficiary has a cause of action against you. He isn't your client, is he? If not, what's your duty to him?
Well, that's a great question because
Yeah.
California was the first jurisdiction, I believe, to abolish the rule of privity. So in essence, before 1950 something, if you're accused of some sort of malpractice, but you're accused by the beneficiary after the client's death, the case gets dismissed because there's no privity. But we changed our laws, and other states followed. Not all of them, but most of them. I understand Texas didn't, so we should all practice there instead. So in essence, this client that says, my dad wanted me to get X, but I didn't get what my dad wanted because of some malpractice of yours. Now, of course, the client has to prove that it was the malpractice of the lawyer, and maybe there's a summary judgment that you can use to get out of it. But that goes back to this conversation where this beneficiary goes to some lawyer, and sometimes, hopefully not too many, but sometimes this litigation lawyer may put words into the client's mouth saying, if it happened a certain way, then you've got a good case. If it happened another way, you'd have a bad case. And all of a sudden the client somehow will adopt that lawyer's version of how it happened and basically move over to that. And you look in your file to see, what do you have in your file to prove that what is being alleged against you didn't happen? Or what do you have in the file to prove that you told something to the client?
And let's see, I don't see any other questions, so I'll pop in a question for the last couple of minutes. I thought one of the many great issues that you raised was about foreign-owned real estate. I mean, I find that older people, either because they've acquired quite a few assets over the years, have real estate out of the country, or older people or people that came here from somewhere else. And so it comes up so often, and quite valuable real estate. What do you do? Should this be, it's almost as if this should be in one's boilerplate warning to someone, because you mentioned you have a pour over will. Well, pour over will, you may be in one of the many countries who don't recognize trusts. Or maybe even the will, I don't even know, maybe it's not even, maybe you need a foreign will and not a US will. How do you handle it? It seems like it's such a common occurrence. And not only that, it's a common occurrence that older people like to kind of sweep under the rug. Is there any other comment on that issue?
Yeah, at a minimum, you want to say to the client, do you have, or might you in the future ever have assets outside the US? So if you get anything warm on that, at a minimum, you exclude the foreign assets from the pour over will, and having a letter countersigned by the client about having a foreign will, because the client isn't necessarily going to go do that. And you could say, you know what, we're not going to do the US estate plan until I see that will. That's one way to go, but some of the things we can have clients, saying goodbye to us, and maybe in some cases we have to push the client out the door too. But the issue for all of us is, which clients do we push out the door and which clients do we do the CYAing with?
Yeah, a great issue. And we have a comment. It looks like it's just a thank you. It's to people drawing everybody's attention to a family code section. Family code, I don't know if you have any comment on that, Randy. Family code 2040B2 provides non-probate transfer does not violate. ATROs provided notice is filed and served on the other spouse before change takes effect. It sounds like it would be a violation. It would be a violation of ATROs to sever joint tenancy without prior notice to another spouse.
Right, but what the point of this,
that's in a divorce.
Excellent point. That joint tenancy has a different rule in this ATRO thing, temporary restraining order, than trusts. It's a harder issue to comply with when you're amending the trust during the divorce, because
Right.
it's not a matter of just giving notice, whereas with the joint tenancy severance, all you're doing is giving notice. But even on that, does the estate planning lawyer for the husband and wife want to get involved in that during the divorce? And the divorce
Risky
lawyer who
business.
should handle it, maybe he understands the issue and maybe he doesn't.
So, hey, good, great comments. And now the only things that are coming in are compliments to you, Randy. So I'll just summarize them and say, incredible presentation, so informative. We all appreciate it. There's a reason that, we're very fortunate to have you come back and speak to us on a regular basis. So thank you, Randy. Thank you, everyone in the web audience. See you guys next seminar. Okay.
Thank you.
Bye all.
Bye all.